Case A 907-619, he's present.
Good morning,
Needs
Judge
that
Kim
remote
Blandino,
recording.
appearing for Kim Blandino.
And Mr. Dickerson is here. I just wanted to hear if the state had any response.
I'd like to note though for the record that they filed no response whatsoever in writing. Therefore, anything Mr. Dickerson has to say can't really be serious. If it was serious, he would have put it in the paper.
Everything that I say.
Thank
is
you very
serious.
much. Go ahead.
Thank you. Our position would be this, is that the defendant has shown no basis for two things. Number one, to regain his right to self-representation, which seems like he's trying to end run here without explicitly saying so. Seems like that's what he's trying to get at. Number two, for taking Mr. Gerstein off the case, Mr. Gerstein has done a fantastic job for the defendant. He's fought tooth and nail at every corner. And there seems to be no basis for his motion and to expend unnecessary resources by appointing somebody new and especially with such a difficult defendant to appoint somebody new to have to take on this defendant, and who knows where that goes. There's also really no reason that any new litigation needs to be occurring. I do think that there's possibly some litigation going on with Metro right now, but I don't know that that's even in this case. I think that's in the Justice Court case. So at this point in time, for three reasons, the self-representation has been revoked. There's no reason to renew that and give him another chance at it. Number two, there's no reason to take Mr. Gerstein off the case. And number three, there's no basis for there to be anything going on in the case since the case is closed.
Well, it's a new proceeding. He filed a post-conviction.
What's
So it's a new proceeding. So, anything else?
Yeah, I'd like to reply to that. I think this man here is slightly delusional because this is a writ of habeas corpus. It is also known as the Great Writ, comes down from the Magna Carta to challenge the legality of the custody.
Here, we're just on the appointment of counsel issue.
Exactly. I filed this representing myself, which I have the right to do. Under WITIS and under the case law on this, which I outlined clearly in there, I don't know if Mr. Dickerson even read this motion.
No, I didn't, because I was not served with that, Your Honor.
He was served with it. If he's going to deny service, I'd like him to do that under penalty of perjury.
My goodness.
So the case is clear on habeas representation and we went through this the last time. A, is the issues presented are difficult, and B, counsel is necessary to proceed with discovery. This being a new case, the revocation of my right to represent myself in the main trial has no bearing whatsoever on this. That's not a perpetual thing that goes to every time I come into every courtroom. Although Mr. Dickerson in Justice Court made it clear to present what happened in this court, and Judge Sacento denied me the right to represent myself in the Justice Court, which should be a disciplinary thing with the bar. But the issues are difficult under Brown versus State Judicial District Court. Counsel is necessary to proceed with discovery. I'm going to have a lot of discovery because the witness is called. You, Judge, do you know that Paul Dyla came and testified against me? He was not called as a witness on direct. He could easily have done so, and they're going to have to subpoena Ducis Tecum, all the evidence that they have at the Commission on Judicial Discipline for this. That's a massive undertaking, plus the letters of caution that were issued based on my complaint. He's gonna have to testify.
All right, so
Okay.
at this time, I think I've heard enough. The court will issue a minute order. Thank you very much.
So
You're not gonna say what your
I'm
determination
going to
is?
issue a minute order.
Okay,
Thank you very much.
okay.
could I just make a quick record that anything that he's serving regarding a petition for writ of habeas corpus needs to be served on the DA's office? It's going to be handled by our appellate section.
I don't know where he served it.
Yeah, I
but
don't know either. I haven't seen.
Where'd you serve it? Did you serve it on? I'm assuming you did because you're telling me you did.
Now the petition is not required to be served. I was presuming he's talking about the motion. But
For the motion.
I did serve him by email on this motion for leave for standby counsel.
All right, thank you
And if I
very
didn't, I
much.
will let the court know if there's a clerical error on my part, then I'll admit to it and fess up. But to my knowledge here, I did serve him. But the other thing,
I
Judge,
appreciate
as
it.
you know, I'd like to have the transcripts as usual.
Absolutely, no
And
problem.
can you order that I get the jabs as well at no cost? Yeah, thank you.
That's all right.
Thank you,
Thank you
Judge.
very
Have a good
much. Have a good
day.
one.
Your Honor.